Joint Appropriations Committee. Mr. Richards, what do we have next on the agenda?
Yes, the next agency for your consideration is Agency 8, the Office of Public Defender. I believe Councillor Booth is here with his team to visit with you.
Great. Come on up. Good to have you here. Thank you for coming. Hope you all are doing well.
We are, Mr. Chairman. Thank you.
Let's, if you can give some introductions, and I'll let you take it away.
Thank you, Mr. Chairman, co-chair, and members of the committee. My name is Brandon Booth. I am a recently appointed state public defender. Been at this for about coming up on 15 months or so now. To my right is my fiscal officer, Ashley Krzwicki, and to her right is my newly selected deputy state public defender, Patricia Patty Bennett. Thank you. If, Mr. Chairman, if the committee would allow, I'd like to start, if possible, with I suppose a brief synopsis as to where the agency is. Thank you. I won't go through all the details that's in my narrative. I know you guys have certainly read the budget book and otherwise, but I want to take a few minutes to give all the committee members, I suppose, a summary as to where we are. As everybody knows, we're a constitutionally mandated agency that was created in 1978 through Article 1, Section 10 of the Wyoming Constitution, and certainly the Sixth Amendment connected to the United States Constitution. Our representation involves indigent clientele charged with serious crimes under the Public Defender Act. As a brief breakdown of the offices, we have 12 trial or field offices. Contained, I guess, connected to that are 3 separate satellite offices, and of course, an appellate division and an administrative division. We have 92 positions. Of those positions, 61% roughly are attorney positions, and the balance is built into legal assistants, 5 investigator positions, and then ultimately the administrative staff. We have currently 25 contract attorney or investigator positions. That breaks down into 21 current contract attorneys and 4 contract investigators to help with that throughout the state, and they're located in different districts to help with that task. Really, the agency's goal is only one goal, and it's to provide effective assistance of counsel through caseload maximums, I suppose, is probably the easiest way to describe that. The National Advisory Commission on Criminal Justice Standards and Goals sets numerical values as to how many cases, how many type of cases any one attorney could have, and roughly it's 150 felonies, 400 misdemeanors, 200 juveniles. And I shouldn't say cases, I should say charges. It's based on charges. And so if you had a case, but it has 10 felony counts in it, they're really looking at number of counts that you're looking at, right? Number of allegations, I suppose. A lot of people, I suppose, maybe I shouldn't say a lot of people, but there's a few that think that standard is outdated. And so the knock on that through the RAND Corporation study is essentially that the NAC standards don't take into effect case weight, how much harder it is to handle a homicide case than a standard drug possession case. We try to do that in our office through a database system. Our database system is a little archaic, but we not only track number of cases, but we track case weight. It's somewhat of an arbitrary system that just gives a weight to different type of cases, knowing that the harder the case is, a violent felony certainly is going to take more time than a standard drug possession, even if it's a felony. So one might be weighted at 10 while another one's weighted at 2. But we try to build that in so that we're always trying to meet that measure connected to our caseload maximums. If you're following along in the budget book on page 11 and 12, you can see that I've listed out as some context some of the cases or the amounts of cases and how they've gone up over the years. In fiscal year 24, the Public Defender's Office handled 13,814 criminal cases and 153 appeals. Fiscal year 25, that number was 13,706 criminal cases and 162 appeals. As a matter of context, when I'm talking about 150 felonies, 400 misdemeanors, or 200 juveniles, That's if you were to handle any one type of case. Certainly, very few offices are able to have just attorneys assigned to felonies or misdemeanors, so it's really an aggregate total across all those types of cases, with Laramie County having by far the largest juvenile docket. The ABA has standards set up for appellate attorneys where their number is about 22 appeals for each full-time attorney, which gets you to about 100 appeals for our division, roughly four and a half full-time attorneys in the appellate division. And you can see from that figure that the appellate division has continued to grow in their work. And although they are certainly an outstanding division, when you start talking about 162 appeals and the number of briefs that come with those types of appeals, that workload becomes pretty significant. All of this is to say that, as you can see, our caseload maximum for the agency itself, as reported, was 98% of caseload maximums, which means we're meeting our goal as an agency. But certainly constantly, I would say, in a state of crisis. I say that because if you look further on pages 11 and 12, Campbell County, at the end of fiscal year, June of this year, was at 144% of caseload maximum. That figure obviously does not include the cases that we didn't work on because of the unavailability. When I declared unavailability in the Campbell County office on February 3rd of this year, they were pushing 200% of caseload maximum, and there was just no other avenue to take. I know that puts circuit courts, private attorneys, and including our office in kind of a jam. I say our office because although we don't handle those cases, the unavailability declaration as of yesterday morning, and this is not counting an invoice we're waiting to be corrected, we've spent almost $250,000 in private counsel to handle those cases because of the unavailability, and certainly to continue our efforts and the state's efforts to adhere to the right to counsel. The issues in Campbell County will continue to grow, unfortunately. I was somewhat optimistic that we would, there's an attorney out of Montana that's been going through the licensure proceedings here. And if I could get that attorney on board, I've been telling Judge Phillips and other individuals around the state that my goal was to remove unavailability at that point in time, as long as nothing else happens. I got notice yesterday that one of our attorneys up in Gillette has resigned, effective December 12th. That puts us now down 5 out of 7 positions in that office. We're trying to cover that weight through contractors that we can find, but in that jurisdiction, there's just, like many jurisdictions in Wyoming, there's a significant attorney shortage, and it's hard to find people that are willing to do the work. Laramie County was the next busiest without any unavailability issues. They're operating at 135% of caseload maximums. They're down 1 attorney at the moment. And because of some of the appellate needs, the appellate division is down an attorney. We thankfully just filled that position yesterday, but we're also filling contractor positions connected to that. And as a result, the Laramie County Trial Division is likely going to be down 2 attorneys before the end of the year. So that number ultimately will go up. I try to fill some of these gaps in various ways, but there's only, I always say threads, there's only so many threads that I can pull from before, if I pull too hard at one, I start to put another office in a bad position. Uinta and Lincoln counties, 121%. The main reason for that is our office supervisor there, Kent Brown, retired. He did a lot of great work there, and losing him and not having a contractor in place at that time left us with 1 attorney. But now we've filled the supervisor position, filled the open attorney position, and have a contractor. So their numbers are improving. We would do great to have another position in that jurisdiction, but I'm certainly not asking for that in this budget by any means. It's just that area of the state does have need. Fremont County is 108%, and that's ultimately because of a similar scenario. The supervisor there stepped down, and so we had to gap fill a little bit for a little while, and that's why they got to that number. Sweetwater is a pretty busy county, so 101 is not unusual for them, but they are above, obviously, caseload maximum, and as I said, the appellate numbers continue to grow. This puts us roughly at a vacancy rate of about, if you look at just our state employees, it puts us at just about 9%. When you add in contractors and everybody, we're about 10, with the contracts that are, I'll use the term vacant, although that's probably not completely accurate. And I suppose this is indicative of recruitment and retention issues, and I think that's certainly what we're running into for various reasons. The real issue comes when the vacancies hit one location. If they're spread out around the state, we can largely absorb it, but when you have Cheyenne go down 3 attorneys and they're operating at 150, 160, that's a struggle. When you have Gillette go down what is now 5 of 7, at one point in time was 6 of 7, it's just not possible, which is the reason for the unavailability declaration that I would love to move out from under, but at the moment, not having much success in that. I suppose there's a question that would be how do you do what you do with all these threads that you're pulling at, and it really comes from the people that work for the agency. They are a committed group of people that work very long hours, work weekends. I can tell you, and this is no exaggeration, from the time I was chief trial counsel in July of 2019 and asked simultaneously to do the supervisor position in January of 2020, when that supervisor stepped down and then COVID came about, I haven't had a weekend where I have had a whole weekend off. And I think the majority of the agency probably operates that way. And so I say that because 98% of caseload maximum, yes, we're meeting our agency goal, but it's not without significant sacrifice from the state employees that we have. And as a result of that, you can see the burnout start to trigger and we start to lose more and more people, and you're constantly chasing that scenario. But I did want to give them a shout out for the work that they do.
Are there
Certainly.
any questions so far? Anything? Okay.
No questions?
Well, now we got 3. Okay. Representative Sherwood and then my co-chair.
Thank you, Mr. Chairman. Thank you for just getting to the meat of this. I mean, when an agency says that they're in crisis, I think we all should be on red alert with you and try to problem solve alongside you. So thank you for the overtime, but that shouldn't be necessary. One of my questions, understanding from the workforce report we saw with A&I and the pay rates, we understand the attorneys are one of the largest gaps we have in the state. So there's a shortage, and then those that we do have, we're not paying a market rate. Just wondering if you could share with us how you feel the pay table adjustments may impact your situation. Will that be enough to sort of offset where you're seeing those vacancies, or do we need to look at a more nuanced solution? Thank you.
Thank you, Mr. Chairman. Representative Sherwood, great question, something I've, in my short time in this position, have been trying to get acclimated to and speak the language. I believe we're at a 2022 pay scale and moving to 2024 from jobs workforce meetings. I think it will help. I don't know if it's a solution that fixes everything. In our area, really where I see a struggle, and I think Director Bach spoke to this, when you have an individual that's been with you for 5 years, those people usually stay, and then they move up a pay scale that's one that will keep them with the agency. When I go to the University of Wyoming and I put the 2022 pay scale out and talk about how it's going to move to 2024, what they see is that 90% in MPP range, and they're seeing and they're thinking, $65,000 straight out of law school. Well, I could go to Colorado, and most of them do. And so I think the goal is, as Director Bach said, to help us recruit and retain attorney 1s and 2s and 3s. And so I think it will help. I don't know if it ultimately fixes it.
Mr. Co-chair.
Thank you, Mr. Co-chair. Director, thank you for being here today. So my question has to do with court-ordered private attorneys having to step in. I think in my community, the judges are saying that they're about to resort to that or have resorted to that. Can you tell us how that works, and have you seen any relief there? Are the private attorneys balking? What are you running into?
Thank you, Mr. Chairman, Co-Chairman Bear. I suppose a smorgasbord of things. Judge Phillips has done a great job of trying to create what he would phrase as a volunteer list to get people to participate in that scenario. We've had people from certainly Wyoming, Colorado. There's some former employees that live out east that are doing it because they can help and do so remotely. I think the issue primarily is, I don't necessarily want to speak on behalf of private attorneys, but when you can charge let's just say, for example, $400 an hour, and now a court's telling you, you need to take this case for the public defender's office. And at one point in time, under the rules of criminal procedure, I think it was $100 an hour. And I met with Justice Fenn and the Rules Committee, and we agreed to move that up to $150 just to try to incentivize people. That figure had been there for probably quite some time. That helped, but you can see that volunteer list ebb and flow. I know when they're flush, which is probably not truly flush, they maybe have 20 to 25 people on that list. People start to get frustrated, I think. I think it takes away from their business a little bit, so they'll take their names off the list for a little while. And when you get down to 8 or 10 or 12 people doing that, that's when it becomes really difficult. And then it'll flow back the little way. So it's helping, but it's not a perfect solution when you're in a jurisdiction that is short attorneys as it is, and you're trying to say, hey, you're a lawyer, you have an obligation to take these cases because people have a right to counsel, and they're trying to take that on, but they can't take on their business scenario. It certainly doesn't make anybody happy. And so it is a Band-Aid solution, and a Band-Aid solution that, like I said, I would love to take away. It's cost us $250,000 so far to do that. But when you're down at the moment, well, what will be 5 out of 7, it's the only solution that I can see. So it does help, but is it a perfect solution? Not by any means.
Follow up, and then Representative Smith, and then Representative Pendergraft.
Thank you, Mr. Co-Chairman. So can you just, for the edification of the public and this committee, explain what the constitutional crisis is that would occur if we didn't provide these public defenders?
Certainly, Mr. Chairman, Mr. Co-Chair. Everybody loses their right to counsel. If you don't have attorneys that can help individuals walk through.
Clarify that. I'm sorry, Director, I just want to clarify that. What would the federal government do about this constitutional crisis is really what I'm getting at.
Mr. Chairman, Mr. Co-Chair, I don't know. I would assume, I would like to think there would be some sort of assistance available, but I don't know. I mean, I think right now it's seen primarily as a state issue, and certainly your right to counsel is not just a state right, it's generated by the federal government, but I think at some point in time, the only solution is, even if you don't want to participate, judges would have to be ordered to tell people you're taking a case. That's how it was before the public defender's office was enacted. People were just assigned and they got some state rate and they moved forward. So I think that's what everybody's trying to steer away from. I don't know how or what the federal government involvement would be in a state crisis.
Thank you, Mr. Co-Chair. Just what I've heard is that we would go basically into something like a receivership where the federal government would be controlling our public defenders and the way we do business in the state of Wyoming to ensure that the constitutional requirement is met. I don't know if that's really how that happens or not, but I just want everybody to understand that's a possibility if we don't keep this going.
Yeah, thank you, Mr. Chairman, Mr. Co-Chair. I don't know. That's a language that I probably don't speak, so I don't want to try to answer. There's other avenues connected to it, like a court has the authority to tell the defendant that they're not going to impose jail in this situation, and so then they don't have a right to counsel. Courts aren't super thrilled about that scenario, and I can understand why they're limited to use that. Yeah, I can't even imagine the level of difficulty that would happen is if we were to see what we're experiencing in Gillette start to happen in Cheyenne and Casper and really in just sprinkling around the state, and the public defender's office could essentially fold. I don't know how you fix that.
Representative Smith?
Thank you, Mr. Chairman. I have 2 questions. Hopefully they're fairly simple, and if you can't answer them now, you can send it to us. But one question is, you talked about being 98% capacity for your caseloads. Is that with the current amount of staff and not vacancies? But if you were fully staffed, what would that percentage drop down to? And then the second question is, what does your caseload look like compared to the prosecution caseload? Meaning, like, what percentage of people would hire their own attorneys or try to defend themselves? Because we've heard cases where people are using AI to defend themselves now and things like that.
Mr. Chairman? Thank you, Representative Smith. I guess I'll start with the second question. The Public Defender's Office handles over 90% of all criminal cases in the state. Very rarely do we have pro se defendants for a handful of reasons. It would be an incredibly poor legal move to do something like that. There are a few out there, but from my perspective, I think the courts discourage it as well. It's hard to have a pro se defendant in your courtroom and how the procedure would go from there. In regards to how our cases compare to a district attorney's office or a county attorney's office, it's hard to probably quantify that. I can tell you that when I was a level 4 attorney, I could never get my caseload, and this was back in 2014 through 2019. I could never get my case number below 130. That was a personal goal of mine, and I'm handling primarily all felonies, but certainly violent felonies and homicides. And so I think it's at least the equivalent, but I know that Mr. Itzen spoke to the fact that they get to deal with, petitions to discharge from probation early or expungement and stuff like that. And so they have a few more wrinkles, I suppose, in that avenue that we wouldn't technically be appointed on, but the Public Defender's Office has, for the 11 years I've been here, handled well over 90% of all the cases, all the criminal cases. As to your first question, 98% is what we were at for the fiscal year 25. I could probably try to run statistics and see what we would be at if we were fully staffed. But it's always moving, it's always in flow, right? I always have vacancy or a vacancy somewhere, and so it's hard to predict that number. I mean, anything under caseload maximum is great. I think an ideal number is probably 85-ish. If we could get to that, you have some counties, Park County and otherwise in the 5th Judicial District, and I use them as an example because if I'm recalling the number from my head, and I could look it up if anybody wants, I think they had 66% of caseload maximums this year, but that is a corner of the state that doesn't quite have as much crime, and they handle Park County and Bighorn, and they help out with Washakie and Hot Springs. That's the 5th Judicial District, which is a gigantic district, and so we always try to factor in things like travel in a district like that, or the 9th Judicial District is another big district, and so it's roughly about 30% of time for travel. So now you're looking at a 66% maximum that's now pushing 90. It's pretty hard to predict what it would look like if we ever had no vacancies. Like I said, I've been here for 11 years and worked primarily in the Cheyenne office. I've never worked in the Cheyenne office where there wasn't at least one vacancy. That's always the case.
Representative Pendergraft?
Thank you, Mr. Chairman. This is indeed a challenging problem. We've got a mandate and nobody willing to do it. We have a couple of programs for medical professionals where we'll help you get through school, but you got to promise that you got to stay in Wyoming for a certain number of years. There may be something similar, it seems like there is, for attorneys to try to get them to stay in Wyoming. In your opinion, do you think that we could put a prerequisite on there that you serve a couple of years as a public defender? It seems like a lot of attorneys I've known got their start that way and then kind of an entry-level type deal. Do you think that sort of an approach might have any kind of an effect?
Thank you, Mr. Chairman. Representative Pendergraft. I think it depends on the person. I say it that way because we had such a JRJ program for years, which was exactly that. Commit yourself to 3 years. I think it was 3 years to the Public Defender's Office, and they pay off a percentage of your student loans. When Ms. Lozano was here and the director of the agency for 17 years, it was in place. I think I was the last one that applied for that in 2015 because I knew I was going to be here for 3 years. I'd done 3 years in Colorado before, and so to me, 3 years wasn't a big deal, especially to get some money to pay back my loans. I think in a generational shift, there's not many that are willing to make that 3-year commitment. I think there's a lot of people that think they can come out of law school and hang a shingle and practice law. You can see the impacts of that belief in the courtroom, in my opinion. And what used to be an incentive to be with the Public Defender's Office was the training and the experience you got, and you could see what you could do for 3 years and then decide whether or not you like that work. Most people seem to believe now that they have the chops to come out and just dive in, and it, in my opinion, is having an impact on how the criminal justice system works, in addition to, what if any people will come and give us a try for a little while.
Okay. Continue.
Thank you, Mr. Chairman. I just wanted to work through, I suppose, some of the budget. I know that you guys have received all the information, and our budget is not complicated by any means, but I don't say that to denigrate the $31 million ask by any means, but there was some requests specifically in regards to the One Big Beautiful Bill, and as I've stated, there's no impact on our agency in regards to that bill. The telework report, our agency doesn't use a lot of telework. We have maybe 4 people, and that was put in place by the previous director, and it's primarily an intermittent telework policy that we use to allow people that are having medical issues or otherwise, or family issues, to work from home when necessary, but we really don't use it a lot. That's likely going to change in the appellate division in order to draw people to that division and handle that crisis. We are working towards 2 days a week of telework and 3 days a week in office. In-office attorneys has such a big benefit to the firm in general, whether it's the appellate division or any field office, for people to talk about cases and otherwise. And so I'm not a fan of telework by any means. Maybe I'm a little old school, but I do think we need to switch that up in the appellate division a little bit, just to help with recruitment and retention in that division in general, and because of the nature of appellate work.
And that's going to push you over that's going to help you?
I think it'll help in, sorry, Mr. Chairman, yes, I think that'll help in the appellate division. I have an attorney that moved here from Texas to Laramie, wants to be more involved in the community, is working remotely, wants to work in her community. Part of the negotiation of that hiring that she just accepted as of today was, do I have the ability to telework a little bit? And the answer to that for her was yes, and so that's what got her on board. I do think that will help with the appellate division. Not an option in the trial division just because of the difference in the work. We supplied our, I suppose what's generally referred to as a 600 and a 900 series, although we don't have a 600 series. And as you can see, those are all contracts connected to interpreters, contract attorneys, consultations or otherwise. The request for the budget, page 18 and 19, the full budget request is $30,875,358. The general breakdown, I suppose, of that budget, of the full budget, $24,313,588 is payroll. Out of the 100 series, that's roughly 79% of our budget. The 900 series is an additional $5,302,538, approximately 17%. So between those two series, the 900 and the 100 series, you're looking at 96% of our budget comes from payroll and contractors to allow us to maintain caseload maximums and provide effective assistance of counsel. The balance, obviously, is just operational expenses. The only true exception request we have on page 16 and 17 is connected to the TRP program through ETS. I don't imagine there's any questions in regards to that, but it's just for laptops and certainly hardware to continue doing the work. There is a portion.
Mr. Co-Chair.
Thank you, Mr. Co-Chair. I do have one question on your exception request, and it shows up on some other things. A small portion is special revenue. I assume that this is fees that you charge. There's a mention in here that the court orders some fees to be collected on your behalf. Is that what that is?
Yeah, Mr. Chairman. It is essentially, what page are you referring to?
Well, the one I highlighted was on page 8.
I just want to make sure I'm responding.
And this is the TRP hardware and software, and it just shows other funds, $13,890. And I guess the question would be, is this a standard percentage, general fund, other funds, or is it just based on your account balance?
Thank you, Mr. Chairman. That's accurate. It's the local match at 15% of the general fund appropriations. So that's what it just falls through, just exactly like that.
Okay, thank you.
Other questions?
There is
Yes,
one.
Mr. Hibbert.
Mr. Chairman. On page 15, I'd just like to point out that this is typical of several years that the governor has made a recommendation that the public defender has superflex, just exactly for the reason that was expressed earlier, the inability to hire staff attorneys and being in a situation where they have to hire contract attorneys. So please add that to a footnote on this budget so we can continue that practice. It's saved us several times.
Mr.
Noted.
Chairman. Thank you. I was just going to make a remark in regards to that recommendation on the governor's behalf really allows us to keep moving forward. I think it kind of stands on its own to be able to move money around like that, although I know there's typically in the past some restrictions to that. The ability to do that is what allows us to do kind of what we're doing in the explanation I've given today.
I appreciate all that you do. The committee has looked at your budget, and we've read it. Any other questions on the exception request? Anyone else? Any other comments that you want to make?
No, Mr. Chairman, thank you.
Okay. Well, thank you so much for, yes, Senator Guru.
Thanks, Mr. Chairman. Just a quick question. On page 18, let me look here. Oh, where is it? Dues, license, and registration, code 207, $236,000. Can I take that your bar dues are paid out of that fund?
Mr. Chairman, yes, Senator Guru, that is exactly right. The Public Defender's Office for years has paid all the attorneys, not contractors, but all the attorneys, as long as you're at a 75% and higher, paid for bar dues.
Thank you.
Thank you.
For coming today. Appreciate what you do.
Thank you, guys. Appreciate the time.
Thanks. You want a break? Want to take a 5-minute break?
That up because every attorney who works for the state of Wyoming has their bar dues paid except for one group.
Right.
And they're going to be here tomorrow. And they're my group.
I hear you. Welcome, everyone. Good to see everyone here. Come on up to the table. Mr. Swindell, good to see you. Welcome. Please, for the public and for everyone, introduce yourselves and then take it away.
Thank you, Mr. Chairman, members of the committee. My name is David Swindell. I'm the Executive Director of your Wyoming Retirement System. I'd like to introduce some of my staff in the back and then the folks here at the table. In the back, I'm not sure, I've got your Chief Benefit Officer, Samantha Mills, our General Counsel, Ben Brandis, and our Audit Manager, Adam Waddell. Also our Budget Analyst from the Budget Department, Fulbert Ware. Hi, Fulbert. At the table, I think you all know Sam Masudi, our Chief Investment Officer, the $12 billion man, as I was calling him this morning. And I think most of you know our Deputy Director, Rachel Maker, to my left, your right. And we're here to present the budget request for the Wyoming Retirement System. We had sent over, Mr. Chairman, a little handy-dandy, one page, 11 by 17 on both sides, that I think was provided to you both electronically and in hard copy. And if I might, I think this might be a useful overview for the committee, and then we can dive into the budget book and we can go into whatever detail the committee wishes.
I will let you know that this committee has looked pretty intently at the budget book. So, but an overview would be great, and then any exception. So, yeah.
Very good. So on the front side, it has our organization chart and a few things that relate to the state of the agency. Just a reminder, The Wyoming Retirement System is a very small agency, but has a really big impact on your constituents in the state. We have 53 full-time people that work in the system. 50 of those are state employees. I have 2 people that are actually ETS employees that are direct billed to us, and I have 1 full-time contractor on the 457 side for deferred comp. So 53 full-time people. In the summertime, we have 2 summer interns, AWIC employees that work in the investment team. And that's been a really good program, by the way. So just as a reminder, we administer all the retirement benefits for not only the state of Wyoming government, but also all the local governments. Our biggest constituency is K through 12. Overall, the system is about 80% local and only about 20% state employees. We have about 36,000 pensioners, 41,000 active employees. We administer 8 plans. We have more than $12 billion under management. It's 12.1 on June 30th. Sam, we at 12.7?
I think we're almost at 13.
Almost to 13. So I was wrong this morning when I said $12 billion man. I'll call you the $13 billion man. We also have another program, the 457 Deferred Comp Program, kind of a 401 voluntary supplementary 401k for government. That's another $1 billion. Last year, we paid out more than $800 million in benefits, $829 million, I think. A lot of that stayed in the state. We have retirees, of course, all over the country, but $647 million went to the state, and that went to about more than 27,000 people. And there's a little map there that says kind of where it's going by county, and you can look at your legislative districts and get a feel for how much money was sent last year to those counties. So overall, Mr. Chairman, I'd say the state of the agency is actually pretty good. Contribution rates are appropriate. The modernization and the IT support we've had over the years has resulted in a pretty good pension administration system. It's headed up. Rachel's done a great job in keeping that going and modernizing it and keeping up with cybercrime, which continues to be a bit of an issue. So but the technology upgrades have been there. They've been supported. Next year, we will celebrate 10 years of auto enrollment for state employees in the 457 plan. New state employees starting in 2016 were auto enrolled into the plan at 3% of wages. And the stick rates, they can opt out, but it just changes the default. And they can opt out, but the stick rate's been 97%. And I think we're about 10 years from now with somebody retiring with 20 years service, which is about average service in the PE plan. And they're going to have a significant sum of money in that account, and it's almost like if it happened by magic. Those are the kind of outcomes that are really positive for all of us in the room. I think past appropriations and support, we've significantly reduced key person risk and some of the operational risk in the system. There's a few more tweaks to do. That's kind of what this budget consists of. You can see the organization chart here. We're proposing 3 reclassifications. Those are the purple squares. Those are just some adjustments to recognize the abilities and some of the duties that have changed. Probably the biggest one is the Chief Benefit Officer, Samantha in the back. When her position was graded and created, it didn't envision or wasn't included oversight of the 457 plan. But that was always part of the long-term goal. We want all of the things that typically impact active members, pension benefits, education, and the 457 plan, to be under one manager to get cohesion and consistency in the message and to solve problems in a consistent way. And we've done that, but her pay grade ought to reflect that. It's another $1 billion program in its own right. We do have some challenges, as all agencies do. Probably our biggest challenge, Mr. Chairman, is staffing. The turnover rate in the Wyoming retirement system is too high. It's twice what it was 2 years ago. In this last year, you'll see that in the workforce report, we had 11 recruitments out of 50 positions. That's a lot. That's 22% of the workforce. We're having trouble retaining folks. We've proven that we can recruit and we can fill positions, but sometimes they don't stay very long. They're hired away by another entity. They're hired away by the private sector. I lost a good budding senior analyst to Colorado Fire and Police. I lost our board administrator here 2 months ago, still haven't filled that position, to Colorado Para. And so we're being outbid. Sometimes we can recruit, but there's too much turnover. It's twice what it was. In the 2023 workforce report, we had 4 recruitments for the year versus 11. That gives you an idea. The good news is we have been able to fill the positions. As we sit here today, we only have 2 vacancies. But there's a lot of new folks on the floor. We filled 4 positions, right in the last 30 days. And I actually counted one person isn't here yet. He reports Monday. I hope he shows up. So that's one challenge. It's a challenge I'm sure you're hearing from all the departments. Cybersecurity continues to be a big risk, and a lot of our proposed IT programming support is going to ever-increasing cybersecurity. We have multi-factor authentication, some of the usual things that you see in your banking, in your private world, but there's new initiatives that are available to us if we take advantage of them, and we have to, because AI is supercharging the criminal effort. We get weekly attempts on the system for people impersonating a pensioner and trying to shift the payment to the criminal's bank account. We have people trying to file a refund for a person that's left their money on deposit, but it's not the real person. And so we're having to adapt various systems to combat that. And I think that's just a continuing war. And I really appreciate the support of ETS in that regard. They're part of our partners in this. The workload has stabilized a little bit. Active employees, we have about 41,000, has been pretty consistent. The number of retirees keeps going up, though. We're running about 10,000 more retirees than we were 12 years ago. And that's because there was a change to the state population, and eventually there was a catch-up in public employees, especially school teachers, in the 80s and early 90s. And those folks are now hitting retirement. And typically a person serves for 20 years, but they'll be retired for about 25. And so I expect that to continue for a little while longer before that stabilizes. The workload is a little more complicated because over the years there have been grandfathered populations and different tiers of benefits and so on. And it's we have systems to accommodate that, but it is a challenge when you're bringing on new people because we want the right information to be provided to employees and retirees, and it's just really hard for a new person to grasp it all at once. But those are our challenges, and with your support, we'll work through them. On the backside of the product is a summary of all of our exception requests. These are organized by kind of functional area instead of by accounting unit. When we get into the budget, you'll see that the Wyoming Retirement System has really just 2 operating divisions. The first division being administration with 2 units, administration and investments. And then we have a separate division for the deferred comp program. There's actually 2 other divisions, Game and Fish and Highway Patrol. Those are legacy accounting divisions to account for revenue that comes into the system from those 2 departments to pay legacy ad hoc COLAs for Game and Fish people and Highway Patrol officers that were hired prior to July 1st, 1987.
Director, let me ask if there's any questions so far. Any questions? Okay. Do we want to start concentrating on the exception requests here?
Very good. Mr. Chairman, you'll see on the upper left of the product, it lists all of our technology exception requests for technology replacement program, software, hardware, licenses, printer, the RAIN system maintenance. RAIN is our Retirement Administration Information Network. That's the pension administration system that keeps track of the more than 100,000 accounts that we keep track of. There's the biggest item there is a programming request for $1,459,000. That buys a contract with our contractors to keep about 1.5 programmers on staff for us. The rate we're paying is $205 an hour, but that is a really good bargain. Usually rates like that will be $250 or $300 an hour. So we think we've always had a good bargain on that. It's not greatly different than in past years. I think in the last biennium budget, it was like $1,402,000. So there's a little bit of an increase to account for inflation, but it's the same thing that we've had for numerous budgets. That's what allows us to keep modernizing the system. There's a contract in there for $300,000 for a cybersecurity consulting contract, about $150K a year. The board is seeking independent verification that we're doing everything we should be doing or can be doing in the area of cybersecurity to protect your member accounts. It's a continuing fight, and we think that'd be helpful. And then there's a kind of a new item of $100,000 to replace the software that the investment team uses to keep track of all of our investment contracts. There are software systems that elegantly track the life and death of an investment manager from the first time we get emailed about them, have communication with them, to the non-disclosure agreements where we do our due diligence, to the investment contract we finally sign with them, and to anything else that happens with that contract. And the legacy system we have has been bought out by another software manufacturer. It's not going to be supported, so we need a new system. And that's what that is. All of these things, that's the technology request. And I guess I'll pause there and see if the committee has any questions on the technology exception request for the system.
Representative Harrelson?
Thank you, Mr. Chairman. It's kind of a theme we're seeing is everything's changing technology-wise. And so not surprised here. Let's talk about the RAIN system a little bit. How long have you had it? And obviously I'm seeing a $1.5 million retrofit to this system. Is this system currently meeting your needs, and will this retrofit system get you how long? When you think of that 1.5 million, is this like a 5-year upgrade, or where are we looking at as far as the long-term projections for this system?
Director?
Mr. Chairman, Representative Harrelson, the Wyoming's RAIN system was put under contract in 2010. It was launched in 2014. So it was based upon the technology that was available about a couple of years earlier than when you wrote the request for proposal, so circa 2008. I remind everyone, it was in 2007 that the iPhone was introduced. So you can see how fast technology has really changed even since the contract was envisioned. The original contract was for about, $12 million, but it came in $2 million under contract. It was easily the largest project ever attempted by the Wyoming retirement system to digitize all records. If you went prior to that, you would have seen rows and rows of black file cabinets with paper files in them. That's where your retirement system was. But the new system actually does the calculations and offered member portals and employer portals for the first time. So it is a huge difference, but it does require continued upgrades and maintenance. And this is not going, the current system does meet our needs, but it needs continual modification, like multi-factor authentication, getting a code on your phone. That wasn't a thing in 2010, right? So that had to be programmed in. And there's all kinds of things that still, when they launched the system, there's still some issues with data migration and data cleansing that were put off to another day. And we continue to make progress on this. So this is a 2-year ask. It's very similar to the number we had 2 years ago, and I suspect it'll be pretty similar to the number we have 2 years hence. You just kind of need we don't have a development staff, so we've kind of outsourced it. That's what this is. Is that helpful?
Follow up?
Please.
Thank you, Mr. Chairman. It is helpful, and thanks for the history. So what we've been riding on is roughly close to a 20-year run on this system. Do you think we're seeing another 20-year run with this upgrade, or is it a deal where you're like, man, please don't make us go another 20 years without putting the wheels back on this type of deal? What do you see, like, just that last part of that kind of look into the future for me?
Mr. Chairman, Representative Harrelson, members of the committee, I think with continued support, as we've had in the past years, this system it's like a Roman road. It can last a long, long time. The previous system was what we call legacy. It was launched in 1999, a Y2K fix, if you remember that. It lasted for about 15 years, and that was considered kind of the normal life of software systems back then. But if you build the system correctly, you build it on a code that is well understood. This is a Microsoft.NET code it's based on. Was developed by a Microsoft developer. Then it can live for a long time because there's lots of people that can code on it, lots of people that are familiar with that language. There's no reason that this can't be like a highway. You've got to repave it, you've got to do mill and overlay, you've got to fog, all that transportation stuff kind of applies to this software system. I think it'll have a long life if we support it.
Any other? So I want to be fair to you and give you the time you need, so please proceed.
Mr. Chairman, the next group
I'm sorry, Senator Guru.
Thanks, Mr. Chairman. Good afternoon. Question on, you said you were working with ETS on all these TRP requests and all that, but then I see the 300,000 for the funding of a continuing service for cybersecurity consultant. What do they do that ETS can't do? Is that a contract that's in place now? Is this a new contract? I didn't quite get that part.
We have one contract in place this year that we just started, that we've taken out of Hyde. This would be to potentially continue that contract or go with somebody else, about $150K a year, to get another independent consultant with specialty in finance and pension systems. Because as I described earlier with some of the cybersecurity things, this is a customer-facing thing with certain cybersecurity risks that are common to every ETS. I mean, we worry about data breaches, we worry about all those social security numbers going out, but we also have payments that can be intercepted and things like that. And there's files we send to the banking system, to our paying agent, and big numbers coming across and contributions from employers and things like that, that may be best addressed by a consultant that's very specialized in these areas. And Jeff Klein and I have collaborated to work on this contract, and that's why you see the CIO approval number on that. It's because he's anxious to have an independent view to make sure that his side of the agency is doing what they need to do to help protect us, because we're linked at the hip. So this is a cooperative thing, and we will share the results, and he will work with ETS and WRS to examine these joint systems that work together to make sure that we're doing everything we should be doing and can be doing to protect your members.
Okay. Mr. Chairman, yeah, I just wanted to make sure the committee knew that it has gone through ETS, they have approved it, and they're working with you on it. I just want to make sure everybody had that. Okay, thanks.
Representative Sherwood.
Thank you, Mr. Chairman. I have a follow-up to that as well. So the funding is for continuing service. It talks about regular review, but then the funding is one time. So help me out there. Thank you.
Mr. Chairman, Representative Sherwood, I don't know if we will actually have a continuing need for this, or if it's going to be more of a periodic thing. It may not be that we need to do this all the time, every year, maybe every other biennium, maybe sufficient. And so I think for now, we're going to see if this has value to us. And I think that was the view, that let's do this for this budget, and let's see if we get a product that is helpful to both ETS and WRS, and we'll see what our continuing need is once we've had some experience here.
Okay, proceed.
Mr. Chairman, the next group in purple there on the left is the schedule of reclassifications. I've talked about one of them. The other one is a modest reclassification for the board executive assistant. This person needs to be more involved with the board scheduling venues, and signing some contracts. And it's a 6-level position that has been regraded to be a grade 7. And we just need the budget support for that. And then the other one is a reclassification of our investment officer, who has served the system brilliantly. I shouldn't mention his name because actually, Casey's brilliant, Casey Rogstad. And he is developing, he's going to be eligible and has all of the makings of a senior investment officer. And we need the authority to reclassify him and give him that promotion. There's another exception request in the, later on I can talk about that's kind of related to this. We've had an issue with maintaining our investment staff at the more junior level and promoting them on schedule as they develop. And there's an existing footnote in the budget that's pretty restrictive, says no increases without legislative action. That means we can't promote somebody. Also, even if there wasn't the legislative restriction on that, then we don't have the budget authority, even if everybody agreed it should be a senior analyst and so on. So there's a budget footnote that asks for some flexibility on the A101, A102, and A103 positions. That's analyst, senior analyst, and investment officer. That would give the board and HRD the authority and the budget to approve promotions within that range. And at any given time, Sam could have 3 junior people. He could have 3 more senior people. We could have any mix, depending upon what the labor market kind of gave us. An exception to that might be once you start talking senior investment officers. These are highly compensated individuals. And perhaps there it is appropriate to have the legislature be involved in that. And this is a request for legislative action to authorize the promotion of an A103 to an A104.
Questions? Yes, Mr. Co-Chair and then Representative Sherwood.
Thank you for being here, both of you, all of you, appreciate it. And Mr. Massoudi and I have kind of discussed this concept, and I am supportive of it, especially since it's being paid out of the earnings that you create for the fund, which is important. And I do believe in a rewards-based pay program. Obviously, that's kind of how you're headed, but you have this inflexibility. First question is, how did we get this footnote in the first place? Many of us are new to this committee. I'd like to know what the discussions were that led to this, and just let you know that I have some questions about the last line of your suggested footnote. The agency's budget authority will be appropriated as necessary. It's giving you that authority, taking it out of the hands of this body. Always want to be careful about that. So that's why the history is important. But I'm going to ask our staff, we typically do these kind of things when we've already given some flex authority to the governor via what's called a B11. And I'm just curious if that's a possibility in this scenario or if it's completely different. And those are my 2 questions, what happened in the past, and can we treat this much like we do the governor's flexibility?
Mr. Chairman, members of the committee, let me talk a little bit about the history, and then I'll have Sam give his version, because the evolution of the investment team is, there's a lot of history there. Some of it's on the chart here with the red and the yellow and the green that you see in the investment results. There was a time when we had no investment operation. The board was selecting individual bond and stock managers. I think they managed a group of about 14 mutual funds. And they did the best they could. But you can see the results there on this chart. And then we evolved. We started to hire an investment team. But it has always been a difficult thing because these are pretty highly paid compensation positions. They will hit the chart on any computer ask of the highest paid people in the state. You're going to get certain vice presidents of the university and some deans, and you're going to get the investment people. You will. So the history of that footnote goes back to 2023, I believe, Sam. Yeah, that's right. When the salaries were last adjusted. Previously, the maximum salaries for these positions were contained in a budget footnote in the budget bill. And in 2023, they were increased based upon 2022 market analysis. And they were increased by a fair amount. I believe 20% is the number that I recall. But the committee at that point wanted to put that into statute. And so it was put into the statute kind of as when there was another change in 2023 to the performance compensation program when the participation for the junior analysts was changed from 25% to 35%. That was a desired change and was helpful, by the way. But that's when that occurred. And when those salaries got put into statute, this footnote was introduced. And I don't know really what the committee's thinking was, because it seemed to me that keeping it in the footnote was a good idea because it gets reviewed every 2 years by this committee. I think this committee is well equipped to examine those kind of things, maybe more so than your colleagues in the broader chambers. And anything you put into statute is by its very nature sticky. And putting wages into statute means that's sticky, but that doesn't necessarily correspond to a dynamic labor market. However, that's what, and if you have control over the number of positions and you have control over maximum salaries, I don't know what the purpose of the footnote really was. I don't think, and talking to some of your predecessors on this committee, it was not the intent to really limit people from being promoted within their grade or even being promoted to the next grade. But that's kind of been the effect. Sam, do you have anything to add to that?
Yeah, just reiterating how restrictive it is for us. And even if the footnote were taken out, we'd still be subject to all the controls going through A&I. We'd have to justify any promotions or any raises, and it would greatly improve our flexibility. But I believe that, only Treasury and we have this footnote. So it is unusual, but otherwise we'd have all the same controls that all the other agencies have.
And then, Mr. Chairman, about the B11 process. That's a possibility, but the trouble of the B11 process is it's one time. And when so we'd say, all right, we're going to promote you, and we're going to use the governor's B11 authority to get the budget authority. That's going to expire at the end of the budget year. And so the person says, well, you're going to keep me on? And I said, well, if the legislature agrees, it just doesn't put us in you can see how awkward that conversation is going to be.
Yeah, I think we run into the same issue with the footnote as well. So, solving the problem in a footnote is, and I understand the stickiness concern too.
Yeah. Mr. Chairman, I would offer that maybe that last sentence isn't necessary. I mean, the way it has come out in the budget, this budget authority is granted and it's built into the budget. Well, that doesn't mean you need to do anything more than that. We budgeted for worst case. Actually, best case, depends on how you look at it. We'd love to have people that are highly qualified and want to stay with the system. That's best case for Sam. I guess worst case for the number in the budget. But again, as you mentioned, this is all 100% other funds. Budgeting here doesn't take away from anybody else's budget like it might in the general fund. And we don't spend it if we don't need it, and we won't. It'll be limited to this purpose and limited to the 100 series, and so we can't spend it any other way. So I think there's adequate controls on it.
With your indulgence, Mr. Richards, do you have anything you wanted to?
Mr. Chairman?
Nothing?
Mr. Chairman, a couple of items just for context and whatnot. This footnote was actually initiated in 2020, so it's been around for 6 years. Part of the genesis of this was the proposal to provide performance compensation in both Treasury and the Wyoming retirement system. And the model that was presented to the legislature at the time had tiered analysts, if you will, for fixed income, for equities, for alternatives, and that each agency kind of added additional cohorts, which would be comprised of more junior folks, analysts, officers, senior officer, all the way up to the CIO. And to keep those tiers in somewhat of a structure to avoid having everyone elevated to, say, the senior status, this was part of the construct that the legislature noted. Two more comments. Around the same time, the director is completely correct. There's no general funds. So they have a unique situation, not unlike the Board of Equalization before you yesterday, where those salaries were being asked for retroactively, meaning the salaries have already been adopted, and they come before the legislature to continue those increases after they've been allocated by the board and the agency. And this agency had a couple of those instances where compensation was increased without the approval of the legislature. So this also restricts the agency's ability to do that. One last point, and that is typically when they were provided a range, not always, but a large majority of the time, the individuals would be hired in at the top of the range. Now, if they could move within the range, the agency would not have that same incentive to hire in at the highest point in the range, because they could move over a number of 2-3 years through that range. So it is a restrictive, and it does result in some unexpected consequences.
Representative Sherwood, did you have something? Okay. Who else? Senator Group.
Yeah, Mr. Chairman, and I'm just going to speak for myself on this. This is a complicated issue, and it really is. And Chairman Bear, I understand, and I feel the same way. It's on the surface, it's their money. It's the money that they've been generating, the fruit of their labor. So we talk about this with the treasurer, what they've done. We also heard from other departments say, we generate so much money, so we should get X. The problem is, there's a lot of hardworking folks in a lot of departments. A lot of them, get grants in other departments that do tremendous service for the state. Sometimes they might feel, well, gosh, I went out and got $4 million in a grant for this, and it saved all these lives. It was an incredible gesture. Maybe I should get a portion of that. We start to go down a little bit of a slippery slope. And so while there's been nothing said here that I disagree with as far as what these folks have earned and what they do, I happen to be their liaison. So while not necessarily being a cheerleader here, I know how hard they work and what they do. I voted to keep this footnote there, and I'd vote to keep it there again, only because I think sometimes we have to take a step back, look at the whole picture, and it's a control that we might want to keep a hold of just a little bit and keep a rein on. Like I say, understand it's their money, understand all that, but also there might be some unintended consequences that this committee may have to answer to outside of this room, outside of this department, because of that. And so that was the why, at least I voted that way in the past. I would say I won't speak for anyone else.
Yes, Mr. Co-Chair.
Thank you, Mr. Co-Chair. Appreciate the senator's comments. Really, this is a different situation. And the reason it's a different situation is because these investors, we're competing with the private market for investors. We're not competing typically with grant writers in the private sector for the government. And so I would not equate these particular jobs with very many other jobs in state government or any other government. So the benefit to making this fund as robust and growing as fast as it can by making great decisions, and those great decisions are based on the intelligence, the intellect, the skill of the people we hire. And I think we've done fairly well so far, but I do believe that taking the handcuffs off when we're competing with the private sector on such a very dynamic industry, if you will, that of investing, I think it has merit. I do agree with the senator that we have to have some sort of control. That's why I suggested, let's start putting our heads together on B11. The reason I mention that is just because I know we get that reported to us on a regular basis. So we have an opportunity to raise our concerns. And maybe that's all it really is. Sam, you're on the IFC with me. I would expect that these kind of decisions, we look to the IFC as well. I would assume that that would need to be in the footnote, that expertise is asked to weigh in on decisions based on the performance, because they're going to be very well aware, especially with Mr. Massoud's conversations with the other members of that board, exactly what's happening in the investment team and why changes need to take place. So those are just a few suggestions that I have, but I don't want to give up complete having a watchful eye on it, and maybe an opportunity to object if we see something that's getting out of hand. But I think you have to be able to really work within a very dynamic economy to get the right people and to perform at the level that kind of we've frankly become used to based on our other investments. And I, for one, am really interested in ensuring that our retirement system continues to perform in a way that our employees can depend upon it.
So I really need to get through these exception requests. So, Director.
Thank you, Mr. Chairman. I appreciate all these comments. I have a lot of respect for everybody. Don, the state is just thankful for your service. I am. So anyway, to summarize that ask, it is kind of a balanced ask, only for the junior positions, not for the senior. If we want to have someone to go to senior, we come to the legislature as we are doing in that exception request. The schedule of new position requests, we're asking for one new position, and that is for an analyst. We'd asked for two, the governor's recommending one, and we'll live with that. A little history here, Mr. Chairman. Back in the day, when Sam came to us in 2013, in 2014, we asked Sam to develop a 5-year plan for the investment professionals, and it had a program of 3 analysts. Some might be senior analysts, might be junior analysts, but there were going to be 3 analysts, and we had that until 2019. In 2018, the system was served with a letter from our external auditors that we did not have an effective investment accounting function. An investment accounting function is where you have someone to independently verify the holdings of the custody bank, independently verify the fees, independently verify the performance, and do that separately and just not rely on the custody bank for that. Eide Bailey, our auditors, characterized that as a serious management deficiency and said that they would have to qualify our financial statements if we didn't fix it. So we went to the legislature in 2019 and asked for an investment accounting position. It was denied. In May of that year, we had a departure. One of our analysts was recruited away, and we, instead of replacing that analyst, we reclassified it as an investment accountant because we had the budget authority, was actually going to be a lower pay grade. And we had our first investment accountant, and we restored that function, but it cost us an investment analyst. So we've been operating with 2 analysts ever since. Now, we have proven since 2019, and there's some green numbers here to prove it, that we can operate with 2 analysts, but it's key person risk. You're at high risk for that. What happens is when you only have 2 analysts, all the seniors have to spend some of their time doing more junior level work. It's not the best use of their time. And then you're at high risk. What happens if one of those analysts leaves? Now you're down to 1. And that's a serious misallocation of effort on the senior part. And then you could even, if you're down to 1, what if they leave? Could that ever happen? Mr. Chairman, both of those things happened this year. In February, we lost an analyst, and we still haven't been able to recruit an analyst at the existing pay rates. We have a person coming in next week we're going to try to interview, and we'll try to bring them in. That position's been vacant since February, so we've been down to 1. And then that 1 left us in August as he was hired away by Colorado Fire and Police. So we've had 0 analysts on staff until 2 weeks ago. We finally hired the senior analyst. He's brand new. But this has caused a lot of turbulence on the team, and it has been a diversion. And what it tells me is just like the quote from Peter Drucker here that we put on there, you don't want to be too big, but you've got to be the right size. 3 analysts was correct. It's the minimum essential level so that we can avoid key person risk, and I would ask the committee to strongly consider that. It's back to the future a little bit, but we've kind of proven that it's really dangerous to operate with less than 3.
Any questions? Any questions? Proceed.
The next schedule of other requests, the flexibility for the more junior investment staff, I think we've covered that one, Mr. Chairman. The actuarial experience study is one of those things, like Representative Sherwood was speaking, you don't need to do this every budget, but every other budget. This is an experience study which we do every 5 years. And this is a review of all the assumptions in the system. We hire an an analyst to go through and see how the systems are holding up with actual experience. That's the name. And then finally, the last one, consider 4 basis point funding for the investment unit. We pitched to the governor saying, look, if you don't want to deal with all of these things on the investment side, just give the board budget authority and put a guardrail on it of about 4 basis points as a portion of assets under management, and let the board make these decisions in conjunction with the Human Resources Department and so on. The governor has declined to support that, and we understand. I would convey to you a couple comments he made as he reviewed that. He says he appreciated the effort to give delegated authority to the board. The retirement board by statute is tasked with the sole management authority over the entire system. It's not an advisory board. It has real teeth. They hire the executive director. They can fire the executive director. They can hire and fire everybody if they wanted to. Any authority I have is delegated from the board. And so it's a real board. It's, as your co-chair mentioned, these with the folks on the investment funds committee, even more so on the retirement board, these are skilled people that know their business. We are fortunate in Wyoming to have a cadre of some retired financial expertise from Wall Street that tends to find Jackson Hole an attractive place to live. And many of them serve on the board. So,
Is your board paid?
Mr. Chairman, nominally, there's 5 people that are at large that have they're not public employees, they're not retirees, and they have no financial interest in the system, and those people are paid $50 a day when they're on board business. Anyway, the governor said he appreciated that concept, but he didn't want to split off the investment part of WRS and fund it differently than the rest of WRS. He said that maybe placing the entire thing with the board at some point and having the board have more budget authority might be an aspirational goal, and we'll work on that. There are some systems out there like that. If you go to Utah, the Utah Retirement Board sets that budget, and they have the legal authority to do it. It is other folks have systems kind of like I would propose, where the legislature does approve that budget, but it is routinely approved as long as it lives within the guardrails that have been established. And the guardrails can be either money guardrails or headcount guardrails or whatever. But there are ways to introduce more flexibility to the system than Wyoming has. Although what we do is not atypical. There are some states that have exactly the same operation we do. And that concludes all of the exception requests for the system, Mr. Chairman. So we'll stand for further questions.
Any questions? Representative Sherwood.
Thank you, Mr. Chairman. Are we going to get to I think there are 2 other exception requests for Highway Patrol, Game and Fish, negative balance, but just walk through that as well. Thank you.
Mr. Chairman, Representative Sherwood, yes, there actually are 2 other exception requests not on the product. And those are reductions in budget authority for the Game and Fish Division and the Highway Patrol Division. As I discussed earlier, those are accounting divisions that account for the revenue that comes to us from those 2 departments to pay legacy COLAs for individuals that were hired in those departments prior to 1 July 1987. That population group goes down every year. I think in one where there's now 11 people and there was 12, and now there's 10 in the other division and there was 12. It goes down every year. Fulbert and I collaborated at one point, I forget when that was, Fulbert, but we wanted to get rid of those divisions because it seemed kind of odd to us, because we don't need administrative budget authority to take in contributions. But it was pointed out by the smart attorneys in the room that the legislation to pay those COLAs did require that the legislature continually approve those things. So there need to be something in the budget that gave visibility to that to the legislature and allowed them to approve something to do that. And it was decided to do it in one place, and that's on the revenue side with WRS. And so that's why those two divisions exist, and that's why there's a reduction that we put in every 2 years to account for the reduced population, just to make sure that it has some visibility.
Any follow-up? Yes.
Thank you, Mr. Chairman. This is kind of a silly question, but from an administrative standpoint, instead of doing a monthly payout over a 2-year period, would it be easier just to divide these amounts by the 10 or 11 people and do one lump payment per cycle?
Mr. Chairman, Representative Sherwood, that's true, but the population is subject to change at any month. People do pass away. And so, yes, we bill those departments on a monthly basis, and it does change, and then no one knows, of course, when that's going to be. The amounts that are listed here are the amounts for the entire 2-year biennium. These are not large COLAs at this point, but yeah, there are lots of ways we could do it simpler, but there we are.
Follow-up?
Thank you, Mr. Chairman. Follow-up regarding COLAs. So cost of living adjustments, that's something that when I'm door knocking, I always get this question of, when are we going to be close to a COLA? Or we haven't had a COLA and inflation has eroded our COLA. So in the spirit of the gentleman who used to sit over here and ask this question, I'm asking it now, if you could give us an update on what is the status of COLAs across the retirement system?
Director?
Mr. Chairman, Representative Sherwood, members of the committee, happy to do that. In 2012, the statute was changed. It used to be, prior to that, the statute required the retirement board to award a COLA as long as it was less than 3%, no greater than the rate of inflation, and it wouldn't cause the funding ratio to go down. It was called a break-even COLA. And the board, the last COLA authorized by the board was in 2008, 1.03%. And that is the last COLA that has been awarded in the system, and you needed to be retired for 2 years in order to get it. You retired in 2006. The great financial crisis caused problems with the fund, as everyone knows. And then in 2012, legislation was introduced and passed as part of some of the retirement reforms that the board could not recommend a COLA to the legislature until the system was 100% funded, plus what would it take to fund the COLA, plus a ill-defined, undefined margin for market fluctuations. And so we're not there yet. The good news is we're in a position now to start growing. The Public Employee Fund, which is our biggest fund, about 88% of our business and assets, is standing right at 80% as it was measured last January. We're going to get a new measurement here this spring. If these investment results hold up for this year, because we're up double digits, Sam, yeah, we'll see what happens by 31 December. Markets can be volatile, but that'll help. And we're going to start growing. This plan, I believe, is going to be funded with these conservative investment assumptions. We're going to hit full funding within the funding policy established by the legislature, which is within 20 years. But still, until we get there, there's not going to be a COLA that the board is going to be able to authorize. It's going to take separate legislative action at some point, either tell the department to take it out of hide and we'll accept a slowdown in getting to full funding, or to appropriate some special money to fund it. That was proposed a couple of years ago in one of the governor's letters, as you know. The other good news is this does happen. You will get to 100% in these funds. The judge's plan is above 100% today. Fire B achieved 100% also. I believe the volunteer fund is going to get there within a couple of years. So once you have kind of repaired the damage and you've set the contribution rates and you lowered your assumptions, then you just stay stagnant for a while and let all that settle in financially. But now we're going to start to grow. It's the old contributions plus investment earnings have to equal the benefits plus expenses. That same equation from the actuaries. We have increased contributions. We have reduced benefits. We've resourced the investment program. All those things are starting to have horsepower, and so we will get there. But right now, it's still a long time, especially in the PE plan. Sorry to say.
Okay, any other questions? Any other questions? Director, thank you so much. Appreciate it. Appreciate you all coming today. And you'll hear from us. Thanks.
Thank you, Mr. Chairman. Happy holidays to everybody. Hope you had a great Thanksgiving and have a great Christmas. Appreciate the committee.
I'll take a 5-minute break. Mr. Richards, what do we have left?
Mr. Chairman, the agenda is complete for today. Just as a headline for tomorrow, there are 2 agencies, the Attorney General's Office and State Construction Department. Although the agenda tentatively has you adjourning mid-afternoon, you may be able to adjourn or work through lunch, the first part of lunch or somewhere, depending on your desires for travel.
Okay. Then with that, we will adjourn until tomorrow.